Life is the only chance we get to experience or make a difference in this world. And taking away someone's life is like taking away their dreams, their hopes, and the future, as well as hurting his loved ones. Namaste, this is Hemanth from LawQuest, and today we are going to talk about the crime of murder and culpable homicide under Indian law. Murder is the unlawful killing of another human being with malice aforethought. Malice aforethought means that the killing was intentional and premeditated. It can also mean that the killing was reckless or indifferent to human life. Culpable homicide is a broader term that includes murder, but also other types of killings that are not as serious. Homicide is the killing of human being by a human being. It is either lawful or unlawful. Lawful homicide or simple homicide includes several cases falling under the general exceptions, which is Chapter 4. Unlawful homicide includes culpable homicide not amounting to murder, Section 299, murder, Section 300, rash or negligent homicide, Section 304A, suicide, Section 305 and Section 306. We will only be discussing about the first two of the unlawful homicides. What does Indian law talk about culpable homicide? Section 299 of the Indian Penal Code states that whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death or with the knowledge that he is likely by such act to cause death commits the offence of culpable homicide. To sum it up, for an act to be called culpable homicide, there must be, number one, causing of death of a human being. Number two, such death must have been caused by doing an act which is with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death or with the knowledge that the doer is likely by such act to cause death. Note that causing of death means death of a human being. It is immaterial if the person whose death has been caused is not the very person whom the accused intend to kill. Now, let us move on to the crime of murder. Section 300 of the IPC explains to which act we call murder. It says, subject to certain exceptions, all culpable homicides are murder if the act by which the death is caused is done, number one, with the intention of causing death, that is, A pushes B off a cliff, intending to kill B. B falls to death. Or, number two, with the intention of causing such bodily injury as of the offender knows to be likely to cause death of the person to whom the harm is caused. That is, A hits B on the head with a cricket bat, intending to cause serious injury. B dies from the head injury. Or, number three, with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. That is, A kicks C in the stomach, intending to cause internal bleeding. C is pregnant and dies from the miscarriage that is caused by the injury. Or, number four, the knowledge that the act is so imminently dangerous, that is, it must in all probabilities cause death or such bodily injury as is likely to cause death and without any excuse or incurring the risk of causing death or such injury as is mentioned above. That is, A sets fire to a building, intending to scare away the occupants. The occupants are trapped in the building and die from the smoke inhalation. To sum it up, all murders are culpable homicides, and subject to certain exceptions, some culpable homicides become murder. So, what culpable homicides do not become murder? These are explained under exceptions of Section 300. Exception 1. Grave and sudden provocation. Anger is a passion to which good and bad men are both subject. The act must be done whilst the person doing it is deprived of his self-control. The expression grave indicates that the provocation must be of such a nature so as to give cause for alarm to the accused. Death caused while accused had lost his self-control will not be termed as murder, rather they will stay as culpable homicide. In popular case of K.M. Nanavati versus State of Maharashtra, K.M. Nanavati, a naval officer, confessed to murdering his wife's lover. He argued that he had acted in heat of passion and should be convicted of culpable homicide. The jury acquitted him, but the High Court overturned the verdict and convicted him of murder. The Supreme Court upheld the conviction, ruling that Nanavati had sufficient time to cool down. The case established the test for grave and sudden provocation in Indian law. Second exception is exceeding the right of private defense. Indian Penal Code provides for the right of private defense under Section 96 under general exceptions. That is, acts done in private defense will not be termed as crime. But what if that person uses more force than required? Supreme Court in Kehar Singh's case said that a man who deliberately kills another in order to prevent that other from pulling his nose should be allowed to go unpunished would be the most dangerous. The law punishes and ought to punish such killing. But we cannot think that law ought to punish such killing as murder. For the law itself has encouraged the slayer to inflict on the assailant any harm short of death which may be necessary. Hence, he will be punished under culpable homicide. The third exception is public servant exceeding his power. This exception protects a public servant or a person aiding a public servant acting for the advancement of the public justice if either of them exceeds the power given to them by law and causes death. It gives protection so long as the public servant is acting in good faith and is authorized by law. The point to the note here is that he must exceed the power given to him by law. Exception 4 is death caused in sudden fight. First of all, fight is not defined under IPC. But it is clear from reading of the section that culpable homicide is not a murder if it is committed without premeditation in a sudden fight or in heat of passion. To bring a case under this exception, the accused should not have had any undue advantage and had not acted in cruel manner. This was held in Vijendra Kumar vs. State of Delhi. Exception 5 is with the consent. Culpable homicide is not murder when the person whose death is caused, being above the age of 18 years, suffers death or takes the risk of death with his own consent. But if the victim is under the age of 18, it has been expressly made punishable under the section 304 of IPC. Now that we have covered all the exceptions and you have understood the difference between the both, you might be wondering why there is a difference between the both in the first place. Why are we trying to make both the crimes as distinct as possible? It all have to do with the nature of the punishment each crime gets. Murder is punishable under section 302 of the IPC, which may be death or life imprisonment and fine. But culpable homicide not amounting to murder, on the other hand, is punished under section 304 with imprisonment for life or imprisonment for term extending up to 10 years. The main difference is death penalty. I hope that this video has made the difference between both the crimes of murder and culpable homicide clear. This is Hemanth and you are watching Law Quest.